Welcome to the virtual rebroadcast of PubCA's 2024 Government Contracts Annual Review. During this week, we are presenting 14 panel discussions featuring more than 70 expert practitioners, as well as 2 in-depth conversations with key government officials. PubCA publishes news and insights for the government contracts community, such as PubCA Protests and Claims, PubCA Cybersecurity and Data Privacy, and PubCA Compliance and Enforcement. In addition to our annual review, we also host webinars, podcasts, and in-person networking meetings during the year. If you'd like to learn more about PubCA, visit us online at pubcagroup.com. All of this week's presentations were recorded live at our in-person conference in February at the Ronald Reagan International Trade Center. You can join any or all of these sessions during the week using the same link and password you used today. All attendees will be in listen-only mode. Your video will remain disabled through the entire session. Many of our panelists are joining us today to answer questions about their presentations. Enter your question into the Q&A box at the bottom of your screen, and the panel will address as many as possible during the webinar. If time allows, we'll open up a live Q&A session after the video presentation. Our briefing book, which includes all of this week's slide presentations and other materials, are available for download from the PubCA website. We are applying for continuing legal education CLE approval in Virginia, California, Texas, Florida, Colorado, and Kansas. While we cannot guarantee approval, we expect acceptance within the next few weeks. We will notify all attendees when those approvals have been received. If you received CLEs for our in-person event, you can apply for additional CLEs for panels that you may have missed. And finally, if you are interested in obtaining CLE, please look for our poll question during the presentation. The state boards require us to verify your participation during the event. The poll is a simple yes/no question. We will keep track of all responses to verify that you viewed the panel. If you do not wish to obtain CLE credit, you can disregard the poll. This conference would not have been possible without the strong support of our event sponsors, all of whom are listed on the next few slides. Our sponsors also provided speakers for our event and other valuable input. We encourage you to review the strengths and capabilities of these firms and to reach out to them directly with any questions you may have. And now we present our next panel, Labor and Employment.
Collaborating with unions, and they said we really want the minimum wage nationally to be $15 an hour. So they jack it up to $15 an hour. Unfortunately, the FAR Council uses the same federal acquisition regulation for both executive orders, right? This has created a ton of confusion out there because this thing is not effective until the FAR clause is in your contract. But contracting officers don't know they have to read the title of the FAR clause to know whether it's effective. So there's a ton of confusion about whether the minimum wage applies at the option years, whether it applies on January 1st, what contracts it even applies to. So this is the skinny, if you're not already up to speed on this. It only applies to SCA contracts or prevailing wage contracts generally. It's not going to apply to other types of contracts. Don't look at the do not look at the wage determination to determine if this thing is incorporated. The wage determinations have some fun language on that makes everybody think that that's what incorporates it into the contract. It doesn't. The FAR clause incorporates it into the contract. Okay? It should have hit in 2022, but if you had long base periods in a contract, it might just be hitting now, right? So you've got to look to see when it was incorporated. Once it's there, the increases hit every January 1st. They don't hit on the option years. They hit every January 1st. So you could have multiple times a year where you're requesting equitable adjustments from the government and adjusting wage rates. You can have January 1st, Then your option hits, your wage determination changes, health and welfare goes up. That's another request. Those are supposed to be in within 30 days. The contracting officers hate this, but this is the way the rule goes, and contractors are required, as of January 1st, we're required to increase from 1620 to 1720. The reason we're getting more questions about this now is because the last 2 years, these rates have really surpassed SCAWD rates in a way that they didn't under the Obama administration. So contractors that really weren't paying attention to it before have to pay attention to it now. The other issue with this is wage compression, right? So I get questions from contractors all the time. But Nicole, if I'm increasing my janitorial staff to $17.20 an hour in Arkansas, and my project manager who's salaried is now making very little, if not, much more than my janitorial staff, can I request a price adjustment from my contracting officer? And the answer is probably not. I mean, you can always ask, but there's no legal obligation for them to provide that adjustment. So when you're bidding on contracts, you really have to be thinking to yourself, okay, this thing has gone up $1 an hour or more, 15 in 2022, 16.20 in 2023, 17.20 in 2024. I don't know what it's going to do next year, but it's jumping at pretty hefty margins, right? And so you really have to think to yourself, I need to plan ahead for those other positions on the contract that I need to hire for where I'm going to experience that wage compression. We're also seeing a lot of wage compression just generally as state minimum wages increase across the board and WDs increase across the board, right? So you can't forget about those salaried folks when you're going in and bidding on contracts when you're bidding on like a base +4, right? You really have to keep that in mind. State laws are becoming kind of a big deal. We expect some, proposed rules on an increase to the salary basis test this year. We all know kind of what happened under the Obama administration with increases to the salary basis test. It didn't go as the Obama administration had planned, but we expect the Biden administration to try to push through something in between what the Obama administration tried to push through and where it sits now, which is around $37,000 a year, which the Biden administration says is pretty low. We saw increases in the salary basis test in New York. Michael, do you know what it is? It's something astronomical, like $60,000 a year. I mean, it's really high. Washington State has an increased salary basis test. California has an increased salary basis test. So if you're hoping to classify folks as exempt salaried, you cannot rely just on the federal minimum salary basis test to determine that. You always have to look at state law. I always tell people the federal contractors get the best of all the worlds, right? You get to comply with state and local law, you get to comply with federal law, and you get to comply with any federal contractor rules and regulations. It's not one or the other. You kind of sandwich them all together, and you figure out what's the most generous of all the things, and that's what you're required to do. And you can't forget that when you're bidding on work, because you'll end up losing some money. I also wanted to talk quickly about the non-displacement rules. They were effective February 12th, a couple of days ago, so they're kind of brand new. Raise your hand if you survived Obama years non-displacement. Anybody in here? Right, so you remember kind of what it was like back then. It sounds great, right? It sounds like everyone's already doing. We're going to make offers of the right of first refusal to our incumbent folks. We're going to do that probably anyway because it's easier. They know the work. We're just going to pick up that staff, right? The problem is that now it's a requirement, right? We do not have a FAR clause yet. So there are some questions about when it's going to hit contracts, but I've seen some contracting officers already throwing it in there and saying, just as a matter of contract, we want you to do it, which creates all sorts of confusion. It is, again, for contracts covered by the SCA. So, if your contract, you got to look, is 5222-41 in your contract, you probably should see or will see a FAR clause when they get around to it, but the non-displacement rules will apply to those contracts. It's going to be a contract for the same or similar work. Notice that one big difference in the Biden EO versus the Obama EO is that it is not required to be at the same work location. Think about how many contracts have converted to remote work from the pandemic. That is created. We could have probably done an hour just on the impacts of remote work on government contracting, right? So not only are you worried about whether you have SCA wage determinations for all of those localities and whether that was incorporated correctly, but you could be required, let's just say call center work. You pick up a call center contract. That work, or medical coding, that work is all over the United States, and you've got to make rights of first refusal to anybody that worked on that predecessor contract. Let's just say you never wanted to do work in the state of California, but the predecessor has a bunch of folks that are working in California. That's going to create all sorts of issues about, what jurisdictions you're subjecting yourself by making rights of first refusal to the incumbent workforce. If you have a call center that's located in Arkansas, but the previous call center was located in Arlington, well, those folks aren't going to move. Why should I make them a right of first refusal? Because you have to. They might not take it, but you got to make them the offer. Under very limited circumstances, a contracting officer can justify an exception to these rules, but they have to do a whole write-up. There's a piece of the regulations that deal with that write-up. And my guess is that contracting officers are going to say, we have enough work to do. It's not our problem, it's your problem. That's my guess, but you can certainly make a play for it and see if they'll make an exception. There are also requirements on predecessor employers that did not exist before. So predecessors were supposed to give contracting officers a list of employees that worked on the predecessor contract. Now the contracting officer can withhold payment and all sorts of things if the predecessor contractor does not provide that list. We'll see how hard COs really push to get you that list of predecessor employees. But the way it's supposed to do, this is the way it's supposed to work. The predecessor employer is supposed to give the list to the CO. The CO is supposed to provide the list 21 days before the start of the new contract. How many folks in the room have seen contracts where you don't even have that much lead time between the date of award and when you're supposed to start onboarding new personnel, right? So we're going to run into all of these timing issues that we also saw before. We're going to see them again. Contractors have to make good faith, written, not oral, written offers, and they have to provide 10 business days, not calendar days, business days for someone to accept the offer. Under the last time around, we did see some employees that would wait until the 10th day because it gave them a little bit of time off. Most employees are going to accept the offers and go to work when they need to go to work, but they have 10 days, 10 business days before they have to give you an answer. And if they say yes, you have to give them an offer of employment. Contractors have an affirmative obligation to notify the CO if they don't think that the clauses are in the contract. So if you think it's applicable, you have 52222-41 in your contract, but there's no FAR clause issued yet. Does it apply? Does it not apply? You now have an affirmative obligation to go out to that contracting officer and say, hey, wait a second, I think you're missing a FAR clause here. You know, it's kind of a see something, say something rule. Again, you do not have an obligation to adopt the same staffing levels. So if the prior contractor did it with 20 folks and you think you can do it with 15, do it with 15. You can make offers to the 15 folks you want to make offers to. That said, this obligation lasts for 90 days into contract performance. So what does that mean for you? You get in there and you decide you hired those 15 folks, you didn't make offers to 5 folks. 3 of the guys you hired or gals that you hired turn out to be lemons. So you write them up, you ship them out. Can you hire who you want to hire? Nope. If it's within that 90-day period, you have to go back to those 5 folks you didn't make offers to and make offers to 3 of them. And so on, at least until the first 90 days. In my experience, it's also been very difficult to convince the Department of Labor, if you fired somebody within those 90 days, that you did so in good faith. So really be careful, make sure you have great records if you need to fire somebody within those first 90 days. And real quickly, because I know we're crunched on time, you cannot apply a screening process outside of those provided by the contracting agency. So if you think that you need to drug test everyone, unless the contract says that you have to drug test everyone, you can't apply those screening processes. Again, you have to give folks 10 business days, has to be in writing. The position could be a dissimilar position as long as the employee is qualified, right? So if you can't get out of this necessarily by just saying, well, I changed them to a clerk 1 and they were a clerk 2, so I'm not going to make them an offer. You can't do that. They're qualified. Just be careful before you try to, skirt some requirements. The job position can include different terms and conditions, right? So I always get this question too. Do I have to offer the same pay and benefits? No, as long as they meet SCA requirements, right? Because these are SCA contracts. So as long as they meet SCA minimum wage benefit requirements, you don't have to offer the same benefits and salary as the last guy did. Talked about staffing levels. If the predecessor retains them, then they're not probably going to take an offer from you. If the contracting officer says, but I don't want this guy, I don't like him, you're going to have to prove that you had just cause for termination on the last contract. Good luck with that. You're not generally going to be able to do that. And then, if you have somebody who's performing federal and non-federal work, you don't necessarily have to make them an offer. That was a lot. Michael, all you.
All right, and now for something completely different. All right, so we'll talk today about two things. Davis-Bacon Act, new regulations, and also the proposed ban on non-competes and the impact on government contractors. So let's start off. Show of hands, who's familiar with the Davis-Bacon Act? All right, a couple people. All right, so let me do a little level setting here. Basically, Davis-Bacon Act is the construction version of the Service Contract Act, roughly analogous. And it applies, you have to pay prevailing wages and fringes for laborers and mechanics engaged in construction, alteration, or repair on public buildings or works under contracts in excess of $2,000 with the U.S. government or the District of Columbia. Pretty straightforward, but the devil's in the details of all those words I just listed out there. What makes this particularly interesting here is that you have the Davis-Bacon Act, which was passed during the Great Depression, but then since then there are about 78 other statutes that have incorporated Davis-Bacon Act type requirements. A variety of HUD loan statutes and other specialized construction, atomic energy, a whole bunch of things. And so this all becomes very relevant because all these other statutes have Davis-Bacon elements built into it. So what Department of Labor has done is they have one set of regulations that is supposed to apply to all of these. So here we go. For the first time since 1982, Department of Labor did an overhaul of the Davis-Bacon regulations last year. They became effective October 23 of last year. And it basically did some major revisions to all parts of the Davis-Bacon regulations. And again, the important part here is that it doesn't just apply to construction contracts directly with the federal government under the Davis-Bacon Act itself, but applies to all 78 of these statutes which incorporate these requirements. So let me talk briefly about some of the changes. This is going to be real high-level slides. You take them home, dip them in water. They'll become a full-fledged presentation later. But given the time restraints, this is what we're going to talk about today. So a couple things. One of the first aspects is that Department of Labor tweaked how it determines what the prevailing wages will be. Basically, it reverted back to the way things were back in 1982, allowing for a 30% rule. Basically, if there's not a majority of employees who are paid the same wage for the same classification, say like masons or electricians or bricklayers, then Department of Labor is now allowed to apply a weighted average for 30% of the workers in a geographic area, as opposed to having to rely on 50% to set the wage. Also, there's authority to now for Department of Labor to adjust the prevailing wages annually based on Bureau of Labor Statistics Employment Cost Index, rather than doing a straight survey. They now have the authority to conflate rural and metropolitan areas from competing wage determinations. If you have a county that or adjacent areas, they're allowed to sort of color outside the lines to allow the metropolitan area wage rates to influence the rural wage rates, and a whole bunch of other things which we'll talk about another time. But I want to hit some of the highlights here, or the lowlights, depending on how you look at it. One of the things that jumped out at me from the new regulations, which are now final, is this new concept called development statutes, which Department of Labor built into its new regulations. And the Department of Labor granted to itself the authority to determine which federal statutes, of any federal statutes, are development statutes that require the payment of prevailing wages under the Davis-Bacon labor standards to all laborers and mechanics employed in the development of a project for which the administrator determines that the statute's language or the legislative history reflected clear congressional intent to imply a coverage standard different from the Davis-Bacon Act itself. In other words, it grants Department of Labor quasi-legislative authority to determine which statutes out there deserve Davis-Bacon Act coverage. That's pretty outside the box thinking there. And so this is particularly applicable in a number of contexts. Among them would be the Inflation Reduction Act, which already has a prevailing wage element to it, but the way Congress set up the statute didn't say that the Davis-Bacon Act applies. It says you have to apply Davis-Bacon wage determinations. But according to this language, Department of Labor could turn around and say, gee, guess what? We now have the authority. We're going to say that Davis-Bacon Act regulations apply to Inflation Reduction Act construction projects. Could apply to military housing privatization initiatives. Could apply to a whole bunch of things where there has not been clear congressional authority to apply Davis-Bacon Act. So kind of strange that the Department of Labor is granting itself this power, but we'll see how that shakes out over time. Some other goodies. A lot of definitional changes. Some of them make sense to update the regulations to reflect the current times we live in. Like the first one, building or work. Yeah, they update the definition to include solar, wind, broadband, car chargers, and other things like that, as opposed to just dams and roads and sort of traditional 1930s concepts of what a building or work is. Let's see, give time. I'll skip to a bunch of these other ones here. Prime contractor. They defined prime contractor to include controlling shareholders and joint venturers. And they changed the definition so that it makes it easier for them to seek debarment or other penalties from all those individuals and entities down the road if there's a Davis-Bacon Act violation. And then finally, near and dear to my heart, they changed the definition of public building or public work. I don't know how many of those in the audience are familiar with the old D.C. Circuit case decided by now Supreme Court Justice Kavanaugh and now Attorney General Merrick Garland, called City Center, which the D.C. Circuit smacked down the Department of Labor as to how broadly it was going to attempt to cover and apply the Davis-Bacon Act to the City Center project here in D.C., which was a private construction on leased government land. And the Department of Labor said that the Davis-Bacon Act applied, even though everything from the ground up was privately owned. And the D.C. Circuit said, not so fast. But here, the Department of Labor is trying to, by regulation, work around the City Center decision. We'll see how likely that's going to be able to stand, especially if the Supreme Court tweaks Chevron deference or anything like that. It should make life interesting. Moving quickly ahead, some of the other interesting enforcement tools. And the reason I mention all these is not just because of the Davis-Bacon Act itself, but typically what you see in the Davis-Bacon Act regulations usually finds their way into the Service Contract Act regulations and vice versa. So these are some concepts which I would expect that if there is a second Biden term or a second Democratic term, that we may see some of these concepts start working their way in. There's some new enhanced record-keeping requirements that employers are required to maintain emails and telephone numbers for all employees, and then, of course, provide that information to Department of Labor when they do investigations. Another goodie, here's the third one down, omitted clauses to be included by operational law. Basically, Department of Labor, by regulation, imposed the Christian doctrine and said that if the clause is missing, then by operational law, it must be there. Now, it throws contractors a bone and says if that happens, then the government is supposed to provide compensation to the contractor, retroactive to whenever it gets incorporated. But still, that's an interesting concept to try to do by regulation here. Again, skipping around, there's new anti-retaliation provisions. There's nothing on the face of the Davis-Bacon Act allowing for anti-retaliation provisions, yet Department of Labor, through regulations, has a very robust anti-retaliation scheme, analogous to what we see under other regulations that have come out of the Department of Labor recently. What else? Fun stuff, mandatory interest payments. Again, the statute doesn't say anything about this, but now Department of Labor has imposed IRS penalty rate interest for any Davis-Bacon Act underpayments. Basically, calculate from the date that they find that the underpayment to when the payments are made. So they're trying to impose a lot more sticks and fewer carrots to try to get contractors to comply. And then, near and dear to my heart, stricter debarment standards. Now there's a mandatory 3-year debarment. The standard now is whether the contractor disregarded its obligations. Before, there were some other heightened standards that implied a certain degree of culpability or intentionality. Here it's just disregard obligations, which is a much more hair trigger for debarment. So, Granted, Service Contract Act has a statutory presumption of debarment, but still, all these concepts I think we will see down the road in the future when service contract regulations are amended and any other opportunities Department of Labor may have. All right, now, for something completely different, let's talk about the FTC's proposed non-compete rule. So basically, last year, the Federal Trade Commission came out with a proposed rule proposing a blanket ban on non-compete agreements. Okay, the comment period ended April 19th, and as stated here below, the Unified Regulatory Agenda shows no target date for issuance of a final rule. In my experience and based on my understanding, FTC is mostly a case that does adjudications, not rulemaking. So who knows when this final rule is going to come out. But looking at the justification in the NPRM for why they proposed this rule, basically it comes down, I'm going to be a little flippant about it, but basically there are a bunch of stores out there, restaurants trying to impose non-disclosure agreements, non-compete agreements on fry cooks to prevent them from going from one burger joint to the next one down the street. I'm exaggerating, but that's generally the sort of level at which they were trying to do it. And so the rationale for doing this was to protect employee bargaining power for wages and working conditions. Okay. Well, but the rationale for that, doesn't really mesh up with the world of government contracting. And so we'll get to that in a second. But the important piece here is that, the FTC proposed a blanket ban. But then they said, well, we're thinking about some other things instead of maybe a blanket ban. So instead, maybe it'd be a complete ban below $200,000 or some dollar threshold of income, and a rebuttable presumption above, or some combination of rebuttable presumptions or absolute bans and dollar thresholds. We don't know for sure, but we're going to take all your comments. We're going to figure something out. So we have no idea what this is actually going to look like. But the irony is that in the proposed rule, that it was not a unanimous proposed rule by the FTC. I believe it was either 3-1 or 2-1. And the dissenting member laid out a very nice roadmap for all the procedural and substantive challenges one could make to this proposed rule. And if a rule ever comes out before the presidential election, I would imagine that somebody will take a shot at challenging it. But the important piece for this group is, there we go, why do we need it? If the need is to protect wages and working conditions for employees, not really seeing it here in this situation, because there are no wage suppression concerns, for rank and file people, because you have the Service Contract Act, you have the Federal Contractor Minimum Wage requirements. These are all pieces in place that by FAR clauses prevent wage suppression. And there's no union suppression concerns because, again, there are FAR clauses that require posting of union rights and other things like that. And finally, there are fewer worker mobility issues, again, by executive order and by other rules that apply to federal contractors. So that, and also some small business concerns I could see popping up here, because it's very possible if all non-competes were wiped out, there may very well be some poaching of talent. Because one of the things that small business and mid-market business can hold on to their personnel is through non-competes. And otherwise, there's going to be a bidding war for talent, and a lot of these small businesses may lose the ability to compete or have their key personnel to do work, which may upend the whole small business regime for federal contracting through the back door, through well-intentions here with the FTC rule. So, careful what you ask for, you just might get it. It's one of those things here with the non-compete rule, but it remains to be seen if one comes out, if it gets challenged, and whether or not, like the blacklisting rule, whether it's subject to the good old Congressional Review Act.
Not to mention all the state laws.
Yes, we don't mention state laws, but again, on the state laws, the idea of the non-compete bans has sort of faded a little bit. It depends on the state. I just read recently that the New York governor vetoed New York's proposed rule, which had been the legislator had proposed for a long time, and the governor ultimately vetoed it. So there's competing headwinds. It's a nice campaign issue, but I don't know how much it's going to come to fruition. And with that,
all right,
pass the baton.
Great, I'm up. Okay, so we're going to talk about the Department of Labor's long-awaited rule on independent contractor status. And so if you have workers in your businesses who do the same sort of work as employees, but they are independent contractors, even if you have, they've formed their own LLC, you're contracting with their entity instead of with them in particular, you need to be concerned about this. Not if you hire someone through a staffing agency or a temp agency or anything like that, where the individual would be receiving a W-2 from that organization, having taxes withheld and so forth. But if you are contracting directly with workers or their own little LLC, and they're the ones doing the work rather than employees of theirs, if they may not have employees, this rule is for you. So essentially, the rule will take effect in March 11th. There are some legal challenges already to the rule. We'll talk about those in a little while. And one thing to know is that it applies to the Fair Labor Standards Act only. So the Department of Labor is responsible for enforcing a whole bunch of different laws. But in this case, the new rule only applies to the Fair Labor Standards Act. So a little tutorial, the FLSA is the federal law that requires payment of minimum wages and overtime for non-exempt employees, essentially hourly employees, who work more than 40 hours in a week. It's a very basic law. It's been in effect for a long time. And this is the rule that will determine who counts as an employee under that law, because it only applies to employees. So it raises the question, who's an employee and who is a contractor who would be exempt from this law that wouldn't apply to it. A little bit of a background. So under the Obama administration and before, up until then, there was no definitive law or rule with respect to the status of independent contractors under the FLSA. And so courts typically use this 6-factor test called the economic realities test. But courts didn't always enforce it the same way. Even different federal courts, in different parts of the country disagreed. There might be one factor or another factor that was given particular weight. So actually, it was the Trump administration whose Department of Labor first issued a rule about who counts as an independent contractor under the Fair Labor Standards Act. And it was, although it was, in effect or in name, a 6-factor test like the ones before, the Trump administration said that there were 2 factors that had particular weight. And this test was viewed as employer favorable or favorable to the hiring entity. The first was that the nature and degree of the person's control over the work. So if you know anything about independent contractors, a lot of the focus is on how much control does the person have over the manner and means of conducting the work. So that was one factor. And excuse me, the second was the individual's opportunity for profit or loss. You'll see these factors incorporated into what the Department of Labor did, but there are many more factors that the Department of Labor is looking at. The Trump rule came into effect January 2021. The Biden administration's Department of Labor first delayed the implementation of that rule and then rescinded it, but did not put a new rule in place. There was a Texas federal court that actually found those two actions unlawful, and that case is still pending. But in the meantime, the Department of Labor took comments and issued this rule in January, effective March 11th. And essentially, under the final rule, the new rule uses the same 6 traditional factors that were in the economic realities test, but explains them in much greater detail and lists quite a few sub-factors or elements that would go into the determination under these 6 factors. Now, the thing to know about independent contractor determinations, for the most part, is it's a little bit like a smell test. You have to look at all the different factors, the entire economic realities and economic relationship of the situation, and then kind of, make a determination as to whether you think this person, and it's case by case, whether you think this person qualifies as an independent contractor. A couple of things that the Department of Labor said when they were issuing this rule, they said that, again, the long-standing multi-factor reality test would be used, and that it relies on the totality of the circumstances. Unlike in the Trump administration, no one factor or set of factors has a predetermined weight, and there may be additional factors considered if they make sense. Okay, so these are the 6 factors to be considered. And I'll talk a little bit about different sort of, again, facts that may go into these. I will say a couple of things. First of all, I think, as I said, if you have someone who is essentially a solo worker, whether they have their own LLC or not, and they're doing the kind of work that your employees typically do, that's a big red flag. So if you have 2 people sitting side by side, or even in different locations in their homes around the country, doing the same kind of work, one's an employee, one's a contractor, that's a big problem. If you have a contractor who is doing the work for which your company actually is in business, so if you're in the business of providing, IT individuals to go on a government site and provide IT services, and you have somebody going on the government site to provide IT services, that's a problem. They are doing the very work for which your organization exists. A traditional idea of who's really an independent contractor, somebody who comes in to paint the office, somebody who comes in most cases, in my opinion, to do management consulting for a short period of time, okay? Or maybe they do coaching, but in addition to working with your company, they work with other clients all the time. So it's not just you keeping them busy all the time. These are the biggest, in my opinion, red flags and big factors that you need to be concerned about. So looking at profit or loss, essentially the person doesn't just get a wage from you, or even a fixed, weekly, or even in some cases monthly contractual payment. They have the ability to earn more or earn less depending on how they do the work. If they hire other people, they might actually be able to leverage the work and earn more from the amount that you're giving them. If they market, they make an effort to, market their business to other companies, other organizations. Their own business acumen or business experience gives them the opportunity to earn more or earn less, and they essentially absorb the risk. Again, like the person who comes to paint your office. It needs to be done in a quality way, but you're not going to be standing there kind of directing what they do first or how they do it. The paint has to be good enough quality, but it's up to them to provide the paint, and maybe it costs less to them, and they're able to realize a better profit. So that's really the opportunity for profit or loss. The worker fixes the price or has the meaningful opportunity to negotiate the price. They can hire others, they can rent space, they have all their own business costs that go into whether they make a profit or not. The second one is investment by the worker and the potential employer. And the Department of Labor made clear it's not just that they provide their own tools or bring their own laptop. That's not sufficient. And it also has to be compared to the investment by the employer. Again, we look at for this, how much is the person acting as an independent business and performing business-like functions? What can they do to reduce costs, to extend their market reach, and that sort of thing? So the investments that they've made in their business the more they've made those investments, the more they've established themselves as an independent business, the more likely it is that they're going to be found to be an independent contractor. And again, you'll see this theme sort of throughout all these different factors. The third one is the degree of permanence of the work relationship. And I see this all the time. If you have someone working for you on an indefinite basis, that's what employees do. So if someone's going to work for you for a permanent's the wrong word, but a long-term or indefinite period of time, that person is more likely to be found to be an employee. What do contractors do? Again, like the management consultant, they come in, even if they work only for you, but it's for 6 weeks or a couple of months, that's fine. They would be more likely to be found to be an independent contractor. Or they work for you sporadically. They come in, they do a project for a month, 6 months goes by, you call them to do something else. That would be an independent contractor. Employees are people that we employ, again, indefinitely. They're at will, but there's no definite end date. There's no project in particular that they're working on. And again, very important that they're not working for other customers or other clients when they're working for you. If you keep them busy for 40 hours a week or full time so that they don't have the opportunity to work for others, even if they have it on paper that they can work for other customers or clients, that's going to be another red flag. The nature and degree of control, that's a really key one for independent contractors. Again, if you limit the worker's ability to work for others while they're working for you, if you have a non-compete clause in your written independent contractor agreements, and of course you have to have a written agreement, those are a big red flag, non-competes. Whether that's during the period that they work for you or after, those are a significant problem. The extent to which the work performed is an integral part of the business. I talked about that before, and so again, if you make widgets and this person's job is to help make widgets, it's a problem from the independent contractor perspective. And finally, skill and initiative. Again, it talks about not just the skills, like they could be a skilled person, highly skilled, and a skill that you don't otherwise have in your company because you need to be kind of setting the right person to do the job. But again, it has to be a business-like initiative on the part of the worker, and no training required from the employer or the hiring organization in order to get the work done. Just a quick thing, I mentioned it only applies to the Fair Labor Standards Act, not other laws enforced by the Department of Labor, not the National Labor Relations Act, not the Title VII or the Internal Revenue Code. There have been a couple legal challenges. One was brought by freelancers who say, hey, look, we want to be independent contractors, which, by the way, also is not a factor. Even if the person wants to be a contractor, they can be found to be an employee under all of these factors that we've talked about. And there's a case pending that would challenge it's challenging the Chevron case. You probably heard about this. Chevron's been in effect since, I think, the 70s. That gives agencies latitude in determining which of their regulations will be upheld, how much discretion do they have. So if that case is struck down and agencies are found to have less discretion, that would make it even more likely that this rule would not be able to survive. And real quick, just one more thing I want to mention. In addition to different federal laws having different tests, the states and the local jurisdictions have their own tests as well. And some of the states use something which is very strict called the ABC test. Definitely need to know about this. There are a lot of big states that use it. I think it's about half the states in the country use it to some extent. And this is a 3-factor test where all 3 factors must be met. And you'll see, again, the same kinds of issues. The person is free from direction and control. They get to decide how to paint the office. You don't get to stand there and say, paint the molding first and paint this afterwards, or supervise their work. Secondly, again, they are customarily engaged in an independent business. That means, again, ideally they have their own company, their own LLC or what have you. That is a necessary factor. It is not sufficient, however. So think of a written agreement and the fact that they have their own company as very necessary to show independent contractor status in almost every case, but not necessarily sufficient. And then the third one, the work is outside the usual course of business of the hiring entity. And some places also say that it could be performed outside your place of business. I think that last factor is really going to lose significance because of people working from home. But again, factor 3 is what I said earlier about the widget factory, basically. So if you market a certain type of service to your customers and you are having individuals that are engaged by you to perform that service, they are more likely to be categorized that they should be employees rather than independent contractors. And I see nothing else here. We have 1 minute. Do you guys want to add anything?
No, the only thing that I was going to add is that we're seeing rules drop all the time. So we just saw pay transparency or pay equity hit, right? And that's going to require federal contractors to post salary ranges for their jobs, and not to ask about previous salaries and things like that. A lot of contractors are already doing that, right? But there's a lot going on. We're happy to answer questions because we're going to get the hook. So I'll kind of.
From a labor and employment perspective, does the future belong to robots?
I don't think so, because lawyers will always protect our own jobs, right? No, I don't think so. But the world's going to change, right? But
let me rephrase. If you're a government contractor employer, would you want to hire employees in this regulatory environment?
You can't hire contractors, that's for sure.
You have no choice. If you have the contract, you want to be able to do the work, you're going to need a workforce to do it. And you got to jump through the compliance hoops.
If anything, I think some of those service jobs will definitely be protected. I think it will be a priority.
But the irony, of course, is that compliance with all this stuff is table stakes to get the federal contracts. So whether you like it or not, you got to do it.
For now, right?
For now. We'll see. And we may have an administration change this year, which could change all of what we talked about today, which is what makes our industry fun, right? All right.
So with that, thank you, Pub
Thanks
Day.
very much. Yeah.
Thank you, everyone, for listening to our labor and employment panel that we recorded back at our in-person event at the Ronald Reagan Center in February. Joining us today, Michael Schreier is here from Husch Blackwell to answer any questions you might have. If you have anything, please put that in the Q&A box. We'll wait a couple of minutes, see if any questions roll in, and then thank you again.
And please don't be shy. I love questions. Challenges about the expansion of the Davis-Bacon Act. I know that there are at least 2 lawsuits currently pending out in Texas in federal court, challenging certain portions of the Davis-Bacon Act regulations, depending on how those cases go. And I like to joke that Democratic administration, Department of Labor regulations go to die in the Eastern District of Texas. So let's see how they all survive current challenges, because like I said, certain pieces were challenged of those regulations. If those pieces are successfully challenged, I would expect that there'll be future challenges to additional pieces of the new regulations. Let's see. CA has double time area of a base is proprietary jurisdiction. Government wants to pay only 1/12. Not quite following the question. Perhaps you could rephrase a little bit. I'd be happy to answer that one. And besides, California is always wacky. I make it a point of telling my clients that I I don't do Windows and I don't do California employment law. So anything I would potentially say here would be, for informational purposes only and without my having studied California law on the issue, which is unique to say the least. All right. Don't know if everybody can see the questions here, but let's see. Thoughts on whether the requirements to offer positions to existing contract employees will result in additional DOL enforcement action of the Service Contract Act, more contracts exposing themselves to DOL claims and referral suspension debarment. That question is sort of conflating the non-displacement rules and Service Contract Act. I've seen some rather vigorous enforcement of the Service Contract Act lately. And to the extent that the Department of Labor has the opportunity to test out its new non-displacement regulations, I fully expect that they will attempt to do so, to create some laws, particularly if there are any gray areas. As long as contractors are squarely coloring inside the lines and following, more or less the plain letter of the regulations and the law, I wouldn't expect there to be an uptick in Department of Labor investigations or enforcement actions. But if there's something that's sort of outside the normal or has a wacky set of facts, I could see Department of Labor finding that intriguing and might be willing to engage in some investigation. Hopefully that answers that question for you all. Anything else?
Okay. Well, thank you, Michael. If there are no more questions, if nobody sneaks one in the next 30 seconds or so, we will close up shop here and give everyone a few minutes back in their day. Michael Schreier from Husch Blackwell, thank you so much for joining us for the live Q&A. Everyone, thank you for joining us today. I hope you enjoyed the presentation and got a lot out of it. We had a great crowd at the in-person event, and I know they appreciated Michael, Teresa, and Nicole's presentation there as well. So we will let you go. Thanks again. And we're going to play a short video and play us out.
Thank you all.
Thank you for joining us today. And thank you to our panelists for their presentations and live Q&A. And again, special thanks to our sponsors whose support made this event possible. The conference will continue tomorrow at 11 a.m. Eastern Time. You can log in using the same link and password you used today. We'll see you soon.